Good evening. This is Rahul Reddy. We are going to bring in election update today about the live results and what's going to happen, when the results come out, as the results are coming in. Emily, one thing I can guarantee to the audiences is that either it's going to be either Trump, the president, or it's going to be the Kamala Harris who's going to be the president. That for sure I can guarantee that. Now, of course, there is also elections going on for the House, which is House of Representatives. Right now, House of Representatives is a Republican majority. And when it comes to the Senate, though, it's a 50-50 vote with a tie vote going to the vice president. So it's in the hands of Democrats. So it seems most likely, based on all the surveys, that we can tell that the House would remain with Republicans and that the House will remain with Republicans, and that for the Senate, though, it seems that it may lean towards Republicans, though. Now, of course, the presidential elections are tied, which is very hard to call, as everybody knows that it's a 7 states, the battleground states or swing states, what they call it as, are going to decide, and the results are not expected to come at least for a couple of hours, at least more. Let's discuss about, Emily, what if the Kamala Harris comes in as the president of the United States, as we both predicted accurately that either it's going to be Kamala Harris or it's going to be President Donald Trump, who is going to be the next president of the United States. So what if Kamala Harris comes in? What do you expect any changes in the current administration, Emily?
Very little that would impact employment-based immigration. I think that she will continue along the same lines as the Biden administration. Her kind of platform is pretty vague when it comes to immigration and her plans for it. She's talking about opportunity for Americans is kind of her goal. And so with that, I think they will continue the steps that they've taken to, attract the best and the brightest, continue to attract STEM workers, figure out ways to utilize our existing system. But I don't see any major changes. I think she indicated that she would bring in that border security deal that supposedly they claim Trump killed a couple years ago. So I think on the border, she's actually more towards the right and more towards enforcement than any of the Democrats that we've had before. But for employment-based immigration, I think it's going to be more of the same. I think not a big priority compared to issues with asylum, humanitarian issues in the border. So we'll be back on the back burner, which definitely could be worse. I don't think there'll be much of anything better. I don't know your thoughts on a Harris administration.
Kamala Harris did vote for removal of the per country limit, Emily, when she was a senator. Definitely that's a positive news, but she hasn't been a big advocate of removing the per country limit. Just because she has some roots of Indians doesn't automatically make it that she's going to do any favor, or not even favor, at least treat Indians equal to among all other immigrant people, instead of having the quota systems which discriminates Indian nationals. She's not a big advocate of removing the per country quota limit, even though she did vote it. As a vice president, she didn't make any move. Because she's the head of the Senate, she didn't move any move in removing the per country quota limit there. So definitely, I think so that it's not going to be worse, but it's going to be standstill if Kamala Harris is going to be the president of this country. Now, what about Donald Trump, Emily? What do you feel if he is going to be the president? What we have already seen him as a president. Mm-hmm. What have you seen, and what do you expect coming?
Yeah, first thing I want to remind people that, even if we get the results today, which is unexpected, but let's say we find out today that Trump is elected, remember, nothing happens immediately. He doesn't take office until January. Even when he takes office, things are going to take time. So just be careful of the rumors. we talked a lot in the 2016 election and the time up to that about fake news. There was a lot of fake news about immigration at that time and things that people were claiming the Trump administration was doing that weren't actually happening. So nothing's going to happen yet. And then when Trump takes office, we kind of had, we already know what the plan is because he's going to continue what he did before. So what exactly did he do before? Pretty much within 2 weeks of taking office, he issued a travel ban for people from certain countries, Syria, Yemen, those kind of terrorist countries in the Republicans' mind. So that happened right away. Nothing happened to employment-based immigration right away, though. The next thing was premium processing was suspended for H-1Bs. I don't think that was necessarily a presidential issue. I think it was more just USCIS was not able to keep up with the processing times. So they suspended that for a time. They've done that under multiple administrations before, so nothing specifically related to Trump. But the big thing started coming in with the Buy American, Hire American executive order. That was issued in April of 2017, so 4 months after he took office. And that kind of rippled down things. After that, we had the H-1B regulation proposals wanting to change how the lottery was conducted, wanting to change how salaries were conducted. He tried to rescind the DACA program. A year later, implemented a new H-1B third-party worksite policy memo that started causing denials to happen of extensions and getting these shortened approvals. Instead of getting 3-year approvals, we were getting 1-year approvals and having to file constantly for that. And then we got the unlawful presence policy for F1 students, which never actually went into effect, but that's what they were proposing, which would have been quite a radical change from prior administrations. More clarification on the employer-employee relationship when it came to H-1Bs that are working for consulting companies and place at end client sites. Public charge rule became the big topic of conversation as he modified how that was going to be looked at. That created that 944 form, all this additional paperwork that was pretty much useless. And then COVID hit, and then we got some more changes that were related to COVID. We had the suspension of H&L visas, the HL travel ban with that presidential proclamation. So that's kind of what we saw over the 4 years of Trump when it comes to employment-based immigration. If you look at his platform, the top number one thing he lists is seal the border and stop the migrant invasion. And that's his words there. That's the first thing they're looking to carry out, the largest deportation operation in American history. Obviously, those are not specifically targeted to employment-based, but we can pretty much assume that what he started before is going to continue, and then more attacks on undocumented population, issues at the border, turning people away who are seeking asylum. I think those are going to be the bigger targets initially for the Trump administration.
Emily, if I look into the two main people that he associates mostly with, a couple of more people, I would say that the Trump administration was associated with Ken, what's his last name? It's very hard.
Cuccinelli.
And also Stephen Miller. These are the two people that are Trump advisors mostly. They are the persons who probably are still going to be in the advisory committee when he's going to take advisors from them. He had some statements made in the podcast saying that he's going to attach the green card along with the degree, though. The Republican Party or neither any of the spokesmen did not elaborate anything more than that. They did not say that they will go with that one. No other comments were made, but based on the advisors that he's associated before and still right now. I think so that they may bring the public charge rule again. Remember the form that, what is it, 944 form, and then it used to be like 18 pages, and we have to submit the income tax returns, property documents from outside the country, even Indian property documents, and all those things that we have to submit. And the Trump administration also did a lot of impediments into the legal immigration, which caused in delay in adjudication of the applications, including the H-1Bs. They've also stopped adjudicating H-4 plus EADs along with the H-1B, which could have been easily adjudicated. They delayed those things all. Also, his advisors, particularly Stephen Miller, did advocate to remove the entire optional practical training and also STEM extension. He also advocated that they try to remove the H-4 EADs. At the time of the Trump administration, we have seen that the H-1B petition extensions, H-1B petition applications were getting denied a lot more. I would say at least 10 times more than the previous administration, and I would say 10 times more than what right now. So between 2016 and 2020, we saw 10 times more denials of the H-1B extensions, and in some cases, even the initial applications too. They also tried to increase the fees. They have increased a significant amount of fees also. They're also trying to increase the fees for the non-immigrant visas. And not to forget that even though this particular topic doesn't touch the legal immigrants, also people feel, but it does touch us. Is the main thing is that Trump does want to ban the birthright citizenship. So if a H-1B person comes into United States and their child is born in United States, the child may not be given the U.S. citizenship if this administration were to have if they can achieve what they want to. They may even end the birthright citizenship. They even went back, commented, especially Stephen Miller, did said that they even want to repeal the birthright citizenship. What does that mean? Repeal means they want to go back and look into all the people whose birth certificate and want to see whom they will think so that will be eligible to get the citizenship. And some of the people whom they were already born in the United States may not be eligible for the citizenship, is what Stephen Miller has advocated. Now that looks to be very challenging going forward in the constitutional wise, though. But still, the mentality of the Trump administration and his administration and his advisor seems to be anti-immigrants. It's not that they just are anti-illegal immigration, but also they're anti-legal immigration. Their stance is very clear from there. Just one statement saying that they're going to attach the green card is not good enough to say that they are going to favor the legal immigration.
Yeah, and although the Trump administration has tried to, or Trump has tried to kind of distance himself somewhat from this Project 2025, the people who wrote the immigration portions of Project 2025 are former Trump advisors. They're still very much advising him on immigration, and they are again wanting that extreme vetting, the fingerprinting that they want for everyone, the interviews for the I-485 process, just all of these little things that grind the system to a halt purposely. I mean, that's their overall plan, is to just limit immigration in general, and without any kind of research or data that backs the need to do that. When we had these biometrics for H-4 extensions, I mean, we're talking about fingerprinting little babies. We had to submit 944 forms for kids that showed whether they had any liabilities or assets and whether they were going to become a public charge. It was just so unnecessary and just gummed up the whole system. It's delay, it's deny, and issue as little as possible to even to legal immigrants. So it definitely is not a great situation if Trump were to be elected. It doesn't improve anything with Harris being elected, but at least I don't think things will get worse under a Harris administration. But I think she's going to be more targeting DACA dreamers, maybe legal dreamers. I don't know if we'll get that far, possibly eliminating the per country cap, but that's all Congress. And she's going to be more border security, I think, than any Democrat we've seen before.
Emily, the next administration is going to actually, even though we predicted that either our prediction is going to come true for sure, I can guarantee that. It's either Kamala Harris or Donald Trump right now. Now, one thing is that either of those people will not be the president of this country until January 20th. That means that this administration is going to be there until January 20th, no matter what. Now, this, we call it as lame duck session. That means that after the election results, all the way until January 20th, the old administration will still remain. Is that true? I know that it's true for the president. What about for the Congress, though, for House of Representatives and Senator? Is that true for them too?
Yes, so we will have a lame duck session regardless of who gets elected, and that, does provide some potential for last minute immigration reform to happen in Congress, as well as on the regulatory agenda. We see a lot of kind of last minute executive orders and regulations from an outgoing administration. And why is that? There's less political pressure on Congress for getting reelected. Some have retired, some are going out of power. At this point, they don't owe allegiance to anyone anymore, so they can do whatever it is they want. There might be some actual legislative priorities that have been given the back burner for some time that now they all agree want to get passed. By then, they're more likely to compromise during this time. And so we have seen over the years a number of bills that passed in a lame duck session that were immigration related. So we do have that opportunity again, particularly for the removal of the 7% cap. We see that moving forward every 2 years, has not crossed the finish line yet, but hopefully this time around we'll have some better advocacy efforts and maybe we'll be able to get it done.
Emily, that's from the legislation, though, which is kind of very tough, though. I have seen the administrations that are going away, though, which one thing is for sure is that Biden is not going to be the president on January 21st of 2025. Can he take some drastic executive orders or probably issue any regulations that may come in force that may benefit immigrants or harm the employment-based immigration? Most probably, I don't think so he's going to try to harm any of the employment-based immigration. But can he do something to benefit the employment-based immigration? Without Congress, without going to the Congress?
Yeah, I think that's where we might have the possibility of seeing an expanded I-140 EAD in line with the White House initiative on Asian and American Pacific Islanders, Hawaiians. I can't remember what the whole acronym is, but that leader of that committee was actually at the Asian Chamber of Commerce Gala that our firm sponsored this last week in Houston. And so maybe we could see something like that go through. Maybe we could see the Biden administration decide, you know what, we're going to reinterpret the statute and say that family members don't need to be counted anymore. I think those are two main things. Maybe we could see some change in how they determine whether a green card is immediately available for the filing of the 485 to allow people to file a 485 much earlier than they've ever allowed before. Those are some of the things I think that we could, potentially advocate for. It's hard to say what will actually come to fruition because there's not really a lot of rumors or leaks about these topics yet. So we'll have to definitely stay tuned to see if any of that could happen as Biden leaves office.
Emily, rules, regulations, laws, and the Constitution, they are there. And of course, executive orders are there too. Now, can the people who adjudicate the applications, though, they also are the same and they don't change that often, is it right? When the administration changes, the new officers won't come into picture, at least a good number of them will remain as they are. Do you see any difference in adjudication when the administration changes, Emily?
For sure. I mean, I feel like every time we have a new administration come in, we start to see new templates for requests for evidence that we didn't see before. Probably the best example in recent years was the level 1 prevailing wage RFEs that we started getting around early 2018, I want to say. It definitely was a result of the Trump administration wanting to give H-1Bs to those that are getting higher salaries, trying to make it more of an elite type of visa category without needing to go through Congress. So we definitely see new trends in types of RFEs, new issues come up in denial decisions when a new administration comes in. Even though the law hasn't changed, it's just a different interpretation, where they have different priorities for who they want to give approvals to.
And Emily, if Kamala Harris comes in, do you see that there will be a drastic changes in the employees' mentality because the president has changed as compared to Biden?
I don't think so. I think on employment-based immigration, her thought process is very similar to the Biden administration. So I don't see any major changes there. I think that they will continue with some of the regulatory updates that they've been planning and continuing expanding things to make it easier to encourage AI and STEM in those important fields, those critical fields. But I don't think we'll see any major changes.
Emily, if Trump administration comes in, though, will the act? You said the action will take a time for them to change, right? It's not going to come immediately. We are not going to see the denials and all those things. But you also raised some points with regards to what going Biden administration, because he's not going to be the president of the country from January 20th onwards. So you said that delayed I-140 EADs. Can you explain more what the administration can do in granting the EADs for the people who are waiting for the green card, whose I-140 is already approved, Emily?
Yeah, so as we know, we have the compelling circumstances I-140 EAD. So it does provide an EAD that provides that work authorization, so you don't necessarily need to maintain your non-immigrant status. But it's very restrictive. It does require that compelling circumstance beyond just waiting for a green card to become available. I think that, and when the compelling circumstance EAD was created, there was no change in the law. That's not something that Congress created by changing the law or passing a statute. That's just something the president did based on the need they felt was there for that particular benefit. And so with EADs, we see a lot of areas where Congress hasn't really said this qualifies for an EAD, but the executive agency comes in and says, we're going to give these people an EAD. And that's exactly how OPT is, STEM OPT. There's nothing in the statute that Congress passed about F1 students getting employment authorization after they graduate. There's nothing in the statute that Congress passed about H4 holders being able to get an EAD. And there's nothing that Congress said that allows for I-140 holders facing compelling circumstances to get EADs. All of that is created by the executive branch, which means the executive branch could expand it even further. So maybe they'll modify that compelling circumstances EAD to make it so kids of the I-140 holders also can qualify, especially when we know that we have an issue with kids aging out. The Child Status Protection Act is not enough for a lot of people that are going to age out. Maybe they could expand it to not just the spouse, but also the kids. Or maybe they could remove the requirement of the needing the compelling circumstance, or state that the green card unavailability by itself is a compelling circumstance. So that's one way we could see some expansion in that I-140 EAD that doesn't require Congress. As something that the Biden administration could do.
Can also Biden administration stop stop counting the family members in the family-based immigration, because they don't count family members in the H-1B quota, Emily?
Yeah, I think that is something that the executive can do because of the way the statute is actually written. The statute is unclear. Actually, in my reading of it, if you look at the plain language and how the statute is structured, it doesn't say anything about requiring dependents to be counted. So he could just reinterpret that statute without needing any act of Congress to stop counting those family members. That's definitely a possibility that he could do it. And has power.
We want all the people who are audiences who listen to our thing, please subscribe to our newsletter at rnlawgroup.com. We're going to post the letters for you to write to the administration, because this is the time they are going to act very daringly. I've seen when the Clinton administration was there, I've seen in Bush administration, I've seen Obama administration, particularly Obama administration has given more than 1 million employment authorization to the DACA kids before he left the presidency. So this is the time where Biden administration, because he's not going to be the president of the country going forward after January 28th, so he could take a drastic decision. He most probably, based on my assumption, is not going to contest for the president ever again. So he can take some very drastic decisions at this point of time. So please keep tuned, not only our YouTube channel, but also to the newsletter, so that we will give you the things very frequently. We may come up with more news bulletins coming forward, because we believe that this lame duck session is the most crucial time for us either to get the legislation passed with regards to not counting the to take up the per country limit, or to have the administration issue executive orders or change their policies with regard to counting the family members, changing the compelling circumstances EAD to actually grant it for 5 years without using the compelling circumstances word, and probably extend it beyond if the priority date doesn't become current. So all those things are to be coming right now. Now, previously we just put some emphasis, but this is the time for you guys to act. This is the time where we think so that the administration can take the drastic decision and the Congress can take a very drastic decision. So please keep tuned in to our RN Law Group newsletter too. Emily, you have anything else before we go to some
Yeah, I just want to add, when we're talking about this lame duck session and the chances for immigration reform to actually be passed, I think most people agree that the most major immigration reform that's happened in the last several decades is the 1996 IRA legislation, Illegal Immigration Reform and Immigrant Responsibility Act of 1996. That was passed in a lame duck session. That was when the Republicans controlled the House. That was when the Republicans controlled the Senate, and Bill Clinton, Democrat, was the president. So there is definitely precedent. There's definitely been situations where major immigration reform has happened during this time period. Now, IRA had a lot of negative things to it. It kind of created the situation that we have today with the undocumented population. It definitely didn't help things in that terms. It had a lot of more enforcement, more border security measures that created the I-9 requirement to verify employment authorization. Clearly, none of that worked to solve our immigration problem. So maybe people have learned from that lesson, and we can get some reform that will actually improve things during this lame duck session.
Emily, IRA went into effect on April 1st of 1997. That's when our office was formed. Just want to remind you. We'll go to the questions, and if necessary, we'll come to, as of now, we don't have any results coming up. But irrespective of the results, it will be either Trump or it will be Kamala Harris. And there will be a lame duck session right now. That's the reason why we want to point out the election results. This election time is very important after the election. That is after November 5th to all the way to January 20th is the time period we can get the things done. That's the reason we put the election results analysis. For those people who are normally tuned to us, you most probably are business immigration, H1B, L1, H4, F1, OPT, STEM extension. These are the people we have. And this is a crucial time for us to act so that we can get it. Please tune in very frequently right now from now onwards all the way to January 20th. Now, once the January 20th comes in, we'll hit a dead wall, guys. I mean, it's going to be a dead wall. So this is the time for us to act. Let's go to the questions, Emily.
Yeah, so Abhi from YouTube says, my husband got a new job offer, and when the transfer was filed, my H4 and H4 EAD were extended along with it. But now he's not planning to join this company. And she wants to know, do I have to raise the H4 and H4 EAD extension again? No, you don't. So although it was filed concurrently with a particular H1B that's tied to a particular company, your H4 and H4 EAD are never tied to the company that your spouse is working for. They remain valid as long as your spouse continues in H1B status with whichever company he has an approval with. So no need to take any action. That H4 is valid until it expires. That EAD is valid until it expires, as long as your spouse is maintaining H1B with one of those companies.
Bhupesh asked this question. Once the kid turned 21, they cannot stay on H4. Is that right? The answer is yes. They cannot stay on H4. They have to move on F1 or pending adjustment of status. Their college education, is this correct understanding? You're absolutely right. If they do have a pending adjustment of status, they don't need F1, so they can stay on pending adjustment of status. That's perfectly all right. Now, the question is that if they move to F1, this question comes out very frequently, though. Now, Bhupesh, normally, though, if they already are in adjustment of status, though, a lot of people tend to choose to stay in adjustment of status instead of filing an F1. Now, some people ask the question, if you're not in adjustment of status, if you move the child to the F1, what if the date becomes current? Well, we are in the period of time where we don't know. I mean, things may change and things may become current in this until January 20th. So what if the dates become current when this child moves to F1 and the child is still under 21? Can you include the children under your 485 application since they moved to the F1? The answer is absolutely yes. Even though they are an F1, even though they are not an H4, they can be included in the 485 application if the child is still under 21.
RK says, what are processing times for H1B extensions plus H4 plus H4 EAD right now? Most of them that I'm seeing are being approved in anywhere from 2 to 4 months. Anything that I've filed in July, August, September, I've been receiving approvals for in the last few weeks here.
It's for me, Emily, or do you answer the question?
Oh, I already answered.
Okay, Murthy has having a question. In case both husband and wife has an H1B, is it a good option to initiate I-140 for both, or is it just one is good enough and the other partner can move on to the H4 EAD? Very good question, Murthy. This is a question of a day. This is what I would suggest for you, Murthy. Have I-140 initiated for both wife and husband. The reason is that, let's say, Murthy, you lose the job. Of course, you can move on to your wife's H4 EAD if your wife have an I-140 approval. What if your wife loses a job and you have a job, then you don't have an I-140. She can't get the H4 EAD. Having both people H1B counted, having both people I-140 approved is the best thing. Now, a lot of people have this question. Once a person moves to the H4 EAD, can they still get the I-140 approval? Absolutely, yes. You don't have to be on the H1B to get an I-140 approval. You can be on H4 and still get the I-140 approval. And when the time comes in, assuming that, let's say, for example, your wife moves to H4 EAD, She gets the I-140 approval and she's working at a particular location. Let's say you lose the job, she can file a H-1B, H-4 to H-1B change of status in premium processing, apply your H-4 plus EAD, get everything approved in 3 weeks. So that is possible. So that's the reason why both people have encountered toward the H-1B, both people getting an I-140 approval is the best thing that can happen for any family right now.
Paris says, I'm on STEM OPT and pregnant. My employer offers 12 weeks of unpaid FMLA, which I plan to use. Will this period be considered towards the unemployment time for STEM OPT? No, it should not, because it is in line with your company's leave policy as well as the FMLA. You're still considered to be employed during that time, even if you're not working. That is how they view that when it comes to H-1Bs and the H-1B prevailing wage and salary requirements. Now, there's no specific guidance out there for STEM OPT, but I can't see them seeing that in any different way. So as long as the leave is approved by the company and it's in line with their policy and it's obviously for a valid reason, that should not count towards your unemployment days at all.
SY has this question. The child is under 21. They filed the 485. They received the receipt notice. Does it mean that they are protected under the Child Service Protection Act? There's one thing you're missing, SY. I don't know at the time when you file the I-485, is your I-140 approved? Assuming your I-140 is approved and you file the 485 application, on the day you file the 485 application after the I-140 is approved and the priority date is current in the either filing dates or final action date, yes, they are protected. But if the I-140 is not approved, though, then we need to look into it at the time I-140 is approved, is the filing dates current or not? If the I-140 is approved at the same time when you file the 485 application, they are covered under CSPA.
Russ, who says, my I-140 was approved through Company A. Company A has never filed the H-1B extension based on that approved I-140. The 180 days are not yet over from the time the I-140 was approved. And he wants to know if Company B can file an H-1B extension using Company A's I-140 approval. Yes, they can. The only risk is if Company A were to withdraw your approved I-140 within 180 days, maybe after you file that extension, but before it gets approved and before the I-140 crosses 180 days, then you would lose the ability to use that I-140 for continued H-1B extensions. So it does not matter that Company A has not used that I-140 to file an extension. You can go straight to Company B, but there is just a slight risk of timing if Company A were to withdraw the approved I-140.
Emily, this question is coming, but I just want some assistance in answering this question of Satish Kotahil. I have an EAD from the pending adjustment of status. If the new administration comes in, what can they mess up? Because my prior date is not current. Some things that get scary to me, in the previous administration, Emily, there was no 540-day rule. The EADs were getting only approved for a period of 1 year. Mm-hmm. And if I recall, there's no 180-day rule either.
There is a 180-day rule for a pending.
180-day rule came in later on, Emily.
For the 485 EAD, I think that was there before. It was the H4 EAD that they created the 180-day rule.
I disagree with you on that, Emily. I disagree with you on that. But let me explain what the Biden administration has done a little bit better on this one is that he started approving the EADs for 5 years, and he increased the number of days that EAD can be used. That means, let's say, for example, if your EAD is expiring in December 1st of 2024, and you file the EAD application before December 1st of 2024, if the application is still pending, you can work for a period of 540 days, even if the I-140 is not approved. Initially, when Biden administration was there, it was actually 180 days. He increased it to 540 days. So he made it a little bit more easier for the people to continue working on the EAD and having the EAD in advance parole for more than 5 years.
Yogita says, I filed my H4 and H4 EAD extension. We were asked to file separately from my husband's approved H1. Am I eligible for the automatic extension? No. The H4 and H4 EAD renewal does not automatically make you eligible for the 180-day or 540-day extension of your EAD. What you need is your H4 status to be extended beyond the end date of your current EAD. So if you filed the H4 and H4 EAD extension together, then you don't have the H4 extended yet. Because your spouse's H-1B extension has already happened, depending on the timing, you may have the ability to do a trip to Mexico and return back showing your spouse's H-1B approval notice to get an extended I-94 for your H-4 status. Once you have that combined with your already filed EAD extension, that's what gives you the automatic 180-day or 540-day EAD extension for H4 EADs.
PS has a H-1B which is expiring in January 31st, but he's traveling to India, but he's coming back in January itself. Does he need to have an extension or the stamping? I'm assuming that you have the H-1B stamping until January 31st of 2025. If that is the case, though, even if you come a week before the expiration of January 31st passport visa stamping, you should not have any problem in entering into the country. Harsha has this question. He missed the car emission test by 6 months. Will it affect the H-1B immigration or I-140? Absolutely will not affect the H-1B or I-140. It will have no impact, none whatsoever at all.
Raul says, I have a pending new H4 EAD application that was filed standalone, been pending for almost 10 months. Now my spouse's H1 is due in 3 months. What would be my options now? Should I include my H4 extension and EAD along with the H1? Yes, I definitely would. The only thing you're losing there is $470 that you've already paid for the first H4 EAD, but it is worth it, especially if your spouse's H1B extension can be done in premium processing. You may be able to get the EAD faster this way than waiting it out for the standalone EAD.
Nandini has this question. She and her husband got the green card, but the kids were aged out. One child is an H-1B, one child is an F-1. Can they apply the family-based application, which is called F-2B, which he rightfully said in the green card? They are under 26 right now. Absolutely. For the H-1B child, you absolutely don't have any problem. You can file. For the F1 also, you can file, but there are some restrictions, though. I may want you to contact an immigration lawyer and also the child be involved in it because there may be some travel restrictions, some visa restrictions that may come up if on the F1 visa person you file a F2B application. Srinivas Raju has this question. Can the EB1C be transferred to another company and the roles and responsibilities are similar in a new organization? Srinivas, I don't know if when you say EB1C, do you mean that you filed an I-140, got an I-140 approval, and you did not file a 485 application? In that case, can you transfer to company B I-140? Answer is no, you cannot transfer EB1C from company A to company B. Now, as people already know that they can transfer EB2 and EB3, but when it comes to EB1C, you cannot transfer. Now, if you have got an I-140 approval, you file the 485 application, and it's been more than 180 days that the 485 has been pending. In that case, though, you can transfer the 485 application to a different company. Absolutely not a problem, not at all.
Rita says, I attended an interview in October 2024 and got an email from the Hyderabad consulate saying that the H-1B was being returned to USCIS for review and possible revocation. Your visa has been refused. There's not, I guess, a question there, but yeah, so typically that happens when either the consulate has done some of their own fraud detection work, or information that you provided during your interview was not consistent with what information the company had provided in the H-1B filing. And so basically they deny the visa stamp and then send the petition back to USCIS to be revoked. Before USCIS will revoke it, they are going to send a notice of intent to revoke to the company, explaining why they intend to revoke it, what was found at the interview or what they found during their fraud detection that leads them to think that that approval is not valid or was issued in error. The company will have 30 days to respond to that. If they successfully respond, the H-1B will be reapproved, and then you can apply for the visa again. If they do not successfully respond, then the petition will be revoked. You'll likely need to look at switching companies to get back to H-1B in the future.
A question from Krishna Woodkuri. His employer filed an I-140 in April 2024. It is still pending, but his 6 years is ending on January 18, 2025. What are my options? My employer is not willing to file my I-140 in premium processing. Oh my goodness, that's so bad. But yeah, there's one solution for you. You can file a H-1B extension for a period of 1 year. I'm assuming that your labor certification may have been filed more than 1 year ago. That means before November of 2020, before January of 2024, which most probably should be the case because it's taking more than 1 year to get it approved. In that instant, though, you can definitely file for 1 year extension. Had your employer filed an I-140 in premium processing, had your employer convert into premium processing, then they can file it in, you can get a 3-year extension. But right now, you'll be only eligible for 1 year extension.
Jay says, my H-1B extension was filed in May of this year and it went to the Vermont Service Center. Is there any way to expedite? A couple of people have mentioned that there's delays in extension approvals in Vermont. The best way to expedite it is to have your employer upgrade to premium processing. If they're not willing to do that, then you need to look at what the current processing time is for it to be considered normal, and if you are considered to be outside the normal processing time. So it asks you to enter the date of filing of your H-1B, and it will tell you when is the earliest date an inquiry can be submitted. But be aware, only the company or the company's attorney can submit that inquiry. You're not going to be able to do it yourself as the beneficiary, because that filing does not actually belong to you, even though it's on your behalf. So really, it's all got to be run by the company to get that process sped up.
Sandeep has a criminal misdemeanor for driving on a car with international driving license involved in a very small accident. Not as a mistake, and he's been fingerprinted. Is that going to have any effect? I would rather want you to consult an immigration lawyer, though. I want to look, the lawyer may want to look into all the documents before he clears off you. Permila has this question. I'm an international IT manager for 1 year. Can I come back to USA on H-1B, or do I need L-1A? I think so. What Permila wants is actually she wants to get into EB-1C application. That's what I would assume, though. If you are on, if you want to get an EB-1A, do you need to come back on L-1A? If you want to get an I-140 approval on EB-1C, do you actually need to come on L-1A? The answer is clearly no. You don't have to come on L-1A. You can come on H-1B, absolutely not a problem.
Rajesh says, my I-140 is in the middle of premium processing. Does USCIS do a site visit in that time? I already received an RFE for company tax documents. I have not seen site visits for I-140 petitions. I don't think that's standard procedure. They are more related to non-immigrant visa petitions. Of course, if there are potential fraud issues, USCIS can always look if they wanted to, but site visits are not really a standard part of I-140 processing. Let's see, where was that? Someone at, Bobbin says, my perm was submitted June 2023. It still shows analyst review in the flag website. It's been more than 1 year and 5 months. Do you see other cases like that too? We do have 1 or 2 straggling cases that were filed in June, July of 2023. It's definitely not the norm, but it's not unheard of to have that. And there's not really anything that can be done. If it's 3 months outside the normal processing time, your employer or their attorney can send an email to DOL about that. Or, we do have a couple of lawsuits that we are working on and have been filed due to the perm delays, but that's about the only options. There's no expedite request process for the Department of Labor.
Bobbin has this question that his labor certification has been filed in June 2023.
That's the one I just did.
Oh, sorry.
Sorry. KR says, my wife is a Canadian citizen and born in India. I'm on H-1B and filing for perm. What are my options here? Well, because assuming you're also born in India, your wife's Canadian citizenship does not help anything in terms of the green card process, because it's going to be based on country of birth. So you can't use spouse cross-chargeability to use her Canadian citizenship. So you would both be under the India category. As a Canadian citizen, she does have the extra option of a TN visa instead of an H-1B, which is definitely easier to get, easier to renew. But otherwise, no benefit in the green card process.
Pradeep has this question. I am an H-1B. I have an I-140 approved, and my wife is on H-4 EAD. Can she apply for I-140 as well? Absolutely, she can. She doesn't have to be an H-1B. She doesn't have to be H-1B ever to apply for the I-140. She can be an H-4 EAD and still apply for the I-140. This is the question, the million-dollar question coming. ARCO. Will for 2016 EB2 become current soon? It depends right now. Now, obviously, if we go in the normal path, though, it may not become current, at least for the next 2 years is our expectation, or even more than that, of course. But the question is that if the current administration does any changes, though, that may really impact the entire, that may really impact your priority date becoming current. If they stop counting the family members, definitely it's going to become current for 2016. It may even become current for all the way to 2017 if they stop counting the family members. So yeah, we may even, if there is some I-140 EAD, that may benefit for you too. So let's advocate for that. Let's follow on that. Let's write letters on it. We already have some letters. We're going to modify those letters in this week so that you can write letters to the administration to stop counting the family members and start using the unused green cards that have been wasted from past 20 years, giving it to the employment-based immigration.
Pradeep says, I'm on H-1B and have my I-140 approved. My wife is on H-4 and has the H-4 EAD. Can she apply for an I-140 as well? Yes, she can. She does not have to be in an H-1B only to qualify. She can be in any status as long as she has an employer willing to sponsor her. She can absolutely have the I-140 filed on her behalf, even though she's on H-4.
I just want to apologize for Emily and me repeating the questions and answers at the same time. When we get live questions, guys. So when Emily is answering the question, though, I'm focusing on reading the question. And when I'm answering the question, she's focusing on reading the questions. So that's the reason sometimes we get to answer the same questions, live questions. These are all whenever we do the live thing, we do answer the questions live from the session. That's the beauty about our Reddy Neumann and Brown, is that we take the live question, we answer, and we are focusing more on reading the question. And sometimes we don't listen to our other partners what they are speaking, and it happens with me and Emily every now and then. Please excuse us for that. You can hear any difference of opinion between me and Emily if there is anything in the particular interpretation. That is a very good source also for you to listen.
Amit says, do I need an I-129 copy for visa stamping in Canada? My nationality is Indian. Yes, I do recommend that you carry a copy of the I-129 petition. It's not necessarily mandatory in every case, but I have seen consular officers ask for a copy of it. The reason it's not mandatory is because of the PIMS system. Basically, every I-129 that's filed, after it gets approved, it gets sent to the Kentucky Consular Center and scanned and uploaded into this PIM system that is accessed by the consular officer. So the officer should already have a copy of the petition. So I don't know why they ask for it, but they can ask for it. So you should have that with you just in case.
Question. Ajinkya Joshi has this question. How does moving houses affect the H-1B LCA? The address mentioned as a work site, I work remotely full-time. You work full-time remotely. That means that you must be sitting somewhere in the world. So if you're sitting in an apartment, if you have an apartment or a house, that should be the location. So if you're moving the house, what do you mean by moving the house? If you move within 20 miles, it still comes under same MSA, or it comes within the travel distance from the existing locations. You're perfectly all right. But let's say, for example, you are moving from California to Dallas, though. Even though previously you were working remotely in an apartment there in California, and now you bought a house in Dallas, you need to get a new LCA. You need to get a new H-1B. You need to get an amendment filed before you even move to Dallas. It is absolutely important for you to do that. There are a lot of people who do the mistake by not updating the LCA and amendment when they move, thinking that, hey, I'm working remotely. How does the government know? They know it. They will just call you. They will go visit. They will knock the door and check where you're working at. And if you're not there, then they'll ask you where you're at. Then you say, oops, I'm in Dallas. Well, you don't have, the H-1B petition says you're supposed to work in San Jose. You're not in the San Jose area, so they're going to revoke your H-1B petition. It's going to create a lot of problem. So this is one of the very common mistakes we see. So if you are changing the location, you have to file an amendment. Now, having said that, if you change within 20 miles, okay, even though you move from apartment to house or house to apartment, not an issue. You don't need a new LCA. You don't need a new, because it comes under the exception of the same MSA or within the travel distance.
AJ says, I'm changing from employer A to employer B with an approved I-140. My priority date is April 2020. Do I have to get the perm filed and the I-140 filed again with employer B? And if yes, when should I ask them to do that? So based on where we are today, we are expecting that an April 2020 priority date is not going to become current anytime in the near future. So you don't necessarily need to start a new perm or I-140 right away with company B, because you might not be with that company when it's time to actually file your 485, however many years that takes. When do you have to have that labor certification and I-140 in place? When your priority date is finally current, you need to have it in place so you can actually file the 485 with whichever company you're at that time. So the main risk there in not filing with the next employer that you go to is, what if your date miraculously becomes current unexpectedly? That's kind of what happened in October 2020. A lot of people were caught off guard. They had just changed employers, and it took them 2 years to get through the process to be able to finally file the 485, but then the dates retrogressed, so it was kind of a mess. So if you want to be in a situation where you're always ready to file the 485, then you can have company B start the process as soon as they're willing to, but you're definitely not required to do that. You don't have to have it in place to keep extending your H-1B with company B. You never have to have an I-140 with them to extend your H-1B as long as company A's I-140 was not withdrawn within 180 days of approval.
One other question that comes from Arul Kumar is that I think so he has an EAD. He's saying that he is pending EAD. I'm assuming that either he has an EAD or he has a EAD extension pending. That means EAD has been approved, but his extension is pending, and he has filed the extension before the EAD expires. If that is the case, his question is that he's working with a company on H-1B. Can he use the EAD to work for a second company while working for the same company A? I'm assuming it's adjustment of status EAD. Absolutely, you can. Absolutely not a problem at all. Anything else, Emily?
Nope, I think we are out of time for today. So stay tuned going forward as we get these election results, and we can work towards some advocacy efforts during this lame duck session and be prepared for whatever the next administration throws at us.
Thank you for tuning in.